everyone. Thank you for watching this video on guardianship and voting, keeping and restoring the right to vote. This video is being recorded in November 2022. I'm Ellen Henningsen with Disability Rights Wisconsin and its Voting Rights and Guardianship Project. Disability Rights Wisconsin, or DRW, is Wisconsin's protection and advocacy agency for people with disabilities. One of the rights we protect is the voting rights of people with disabilities. I'm going to be talking to you today about the voting rights of people with guardianships. One important task of DRW is to operate the DRW voter hotline, and you'll see on your screen the toll-free number and the email address. If you have any questions about voting, barriers to voting, curbside voting, how to get a photo ID, where your voting place is, any question you have about voting, feel free to call year-round that number or email at that address. One of the important services that DRW provides is a voter hotline available year-round to answer any of your questions about voting. Questions might be, how do I get an absentee ballot? How do I do curbside voting? Will there be an accessible voting machine? Any and all questions. The toll-free number is 844-347-8683, or you can email info@disabilityvote.org. I'm going to be talking to you about the law on keeping and restoring the right to vote. This topic impacts three groups of people. It impacts minors with cognitive impairments who are transitioning to adulthood. They've never voted before because minors can't vote. The goal of this presentation is to teach you, if they are going to be placed under guardianship, how to retain the right to vote, and if they lost it in a guardianship case, how to get it back. The other group of people this law affects are adults with no history of cognitive impairments who have an accident or a progressive disease which impacts their cognition. They have a voting record. They want to continue to vote. And so this topic addresses the law about how they can continue to vote, even though they might have a cognitive impairment. And finally, the group of people this covers are elders who have no history of cognitive impairment, who decline cognitively due to dementia or other impairments. They too have a history of voting, and we will discover how they can continue to vote after their decline. The topics I'm going to be covering are these. We're going to start with a video message from Jen, a voter, who lost her right to vote when she was placed under guardianship, and then she got her right to vote back. We're going to be looking at two new guides on how to restore your right to vote. I'm going to be talking about the basics of voter eligibility, guardianship law, election law, and guardianship law combined. Then we'll turn to how to keep the right to vote in a guardianship case, how to get the right to vote back if you lost it initially, how to prove the capacity to vote. We'll look at some resources, and I'll do a brief summary. Before I turn to the video, I want you to listen for some key points. Listen to how Jen was inspired by another person to get her right to vote back. Note that she had the support of her guardian, she had the support of an advisor, and particularly note how joyful she was about getting her right to vote back. You'll also notice that she knew why she wanted to vote. So let's look at this video.
You are watching How I Got My Right to Vote Back, a video message from Jennifer Kratsch, voter and self-advocate from Disability Rights Wisconsin.
Perfect. Hi, I'm Jennifer Kratsch. I am a self-advocate and I got my right to vote back. I'm excited to share my story with you all about how I got my right to vote back. I hope you all can have the same experience that I did.
Hi, I'm Barbara Becker with Disability Rights Wisconsin. The right to vote is one of the most cherished rights in our democracy. In Wisconsin, people under guardianship retain the right to vote unless the judge expressly removes that right. If you have lost the right to vote, you can petition the court to have your right to vote restored. Thank you, Jen, for sharing your story of how you got your right to vote back and inspiring other people. Jen, how did you find out that you lost your right to vote?
After I had my right, after I had got guardianship, the judge said I was incompetent of voting and said that I didn't have the knowledge or the process of voting. And then after I went to the self-determination conference in 2015, I heard a lawyer tell a story about Jenny Hatch of how she lost all her rights, and that's how I wanted to get my right to vote back. So that next day, I called my guardian and asked her if I had my right to vote. But if I had my right to vote, she had to look through the guardianship papers, and she said no. And then when she asked me if I wanted to get my right to vote back, and I said yes.
Jen, once you decided you wanted to get your right to vote back, that's a process. Who helped you to get your right to vote back?
Susan Howard is one of the advisors of the Ozaki People First chapter, and she helps me out a lot when it came to that.
Jen, can you tell us what you did to get ready for your court hearing?
I had a guardian ad litem lawyer come to Portal and ask me questions if I was ready for the court date, and I said yes I am, and I was ready to get my right to vote back so I can start voting.
What was the process like in court? What did the court ask you?
The judge asked me if I if I wanted my right to vote, and I answered yes. I told him I wanted to experience voting because I never experienced that before, and he said that he was happy to give me my right to vote back, and so he granted me my right to vote back, and I've been voting ever since then.
That must have been a very exciting day when you got your right to vote
Yes, it was.
restored.
I even made sure it was okay with the judge if I could go sit up in his chair, and he said yes I could. So that's why we got a picture taken. It was up there, me in his chair and him right next to me.
Oh, that's great that you've got a picture that captures that moment. And I've seen it before, and you look so happy, Jen. It was a big day for you and a big day for voting rights. Yeah, Jen, why is it important for you to vote?
Because I get to pick who I want to vote for instead of other people telling me who I should vote for and telling me what their opinion is on the person when it's my opinion on who I want to vote for, not theirs.
Jen, thank you so much for sharing your story about how you got your right to vote back and motivating other people to consider getting their right to vote back too.
I hope you found Jen's video motivating. She's an inspiring example of an individual who recognized that she had lost something when she was placed under guardianship, who understood that she could get her right to vote back because she knew why she wanted to vote. I'm now calling your attention to two new guides that DRW has published. I'm going to be giving you a lot of information in the next several minutes, and it'll be probably hard for you to remember it all. So DRW has produced two guides on guardianship and voting, how to get your right to vote back. The first one is a detailed step-by-step guide, 19 pages. It includes legal forms that you'll need and instructions. It's on DRW's Guardianship and Voting page with a link noted in the PowerPoint. DRW has also published a summary, a shorter guide, only 4 pages. It's a quick reference. It's also on the DRW Guardianship and Voting page. It doesn't have as much detail, but it is a useful summary. So I would recommend that people watching this video go to DRW's website and look for the Guardianship and Voting page. So that we're all on the same page, let's review some basics of voter eligibility. You need to be a U.S. citizen in order to vote. There are additional requirements as well. You need to be a resident at the current address in Wisconsin for 28 days prior to the election. If you have moved within those 28 days, you need to vote at your prior polling place, your prior address. You cannot be currently serving a sentence for a felony, treason, or bribery conviction. And the sentence means being incarcerated, being on parole or probation or extended supervision. That's known as being on paper. You cannot have made a bet on the outcome of the election. And finally, you cannot be determined by a court to be incompetent to vote. This last point is the point we'll be spending the next several minutes on. Now, some basics of guardianship law. Many people assume that someone with a guardian automatically loses the right to vote. People assume that guardianship means the individual with a guardian cannot vote. And that's wrong. That's 100% wrong. In Wisconsin, rights cannot be removed by a general finding of incompetency. Rights are retained unless expressly removed by a specific finding of incapacity regarding that right. To determine whether a person with a guardian can vote or not, we have to know 2 things. We have to know what type of guardian was appointed, and we need to know what rights were retained by the individual or removed from the individual. So let's look at the types of guardians. In Wisconsin, there are 2 types of guardians. There's a guardian of the person, and there is a guardian of the estate. The guardian of the person is authorized by the court to make specific personal decisions for another person. And that individual, that other person, is called a ward under our law. There's also a guardian of the estate. That individual is authorized to make specified financial decisions for the ward. Now, a court has several options when appointing a guardian, and those options depend on the capacity of the individual. One option is to appoint both a guardian of the person and a guardian of the estate. Another option is to appoint only a guardian of the person. And finally, an option is to appoint only a guardian of the estate. So you need to know what type of guardian was appointed. If it's only a guardian of the estate, voting rights can never be lost. They can never be removed if only a guardian of the estate is appointed. And it is possible that some individuals lack the capacity to manage their finances, but are perfectly capable of managing their personal affairs, like where they live and what medical care they get, etc. So that individual would only have a guardian of the estate, and they would never lose their voting rights. But if a guardian of the person is appointed, it's possible that someone could have lost their voting rights, and I'll get into that in more detail. If a guardian of the person is appointed, you need to know the scope of that guardianship. You need to know what rights the individual has retained, what rights they have lost but were not transferred to the guardian, what rights were transferred to the guardian, and what rights are shared with the guardian. And the answer to those questions is found in one document, the document that's called Determination and Order. We'll look at that in a minute. That's a document people generally call their guardianship papers. And you heard Jen mention her guardianship papers, and she was referring to the Determination and order. Now, when we look at both election law and guardianship law in Wisconsin, there are several important things to remember. Only a court can remove the right to vote of a person alleged to be incompetent to vote. I'm going to stress that, only a court. The procedure for removing the right to vote is found in Wisconsin's guardianship law. So the same procedures that apply to a guardianship process apply to losing the right to vote. Because only a court can remove the right to vote cannot be taken away by a guardian, by a parent or other family member, by an election official, a service provider, a teacher, or a power of attorney, even if the power of attorney is activated. So if an individual has not lost the right to vote in a legal proceeding, and they indicate with assistance or without assistance and without coercion that they want to vote, they must be allowed to vote. Continuing with our look at election and guardianship law, the standard in the law for removing the right to vote is incapable of understanding the objective of the elective process. It's a mouthful, but that's what the statute says. Incapable of understanding the objective of the elective process. We'll talk about that more in a bit. If the right to vote is removed, it cannot be exercised by the guardian. The guardian of the person will never have any authority to vote instead of the individual with the guardian. And the last important point about election and guardianship law is that an individual who has lost the right to vote can petition the court to have their right to vote restored. We'll be going into that in more detail as well. So, how to keep the right to vote in a guardianship proceeding? The rule of thumb is it's always best not to lose the right to vote in the first place. I'm sure you can imagine it's easier to keep something than it is to lose it and get it back. Filing for guardianship, unfortunately, puts the right to vote at risk. I should clarify that. Filing for guardianship of the person puts the right to vote at risk. Because as I already explained, if you're just asking for a guardian of the estate, the right to vote is never lost. Guardianship of the person does place at issue the right to vote. And in a guardianship proceeding, it's the court that controls the outcome. It's not the person filing for guardianship. That person's called the petitioner. And it's not the person who we call the proposed ward. The court controls the outcome. And the court may remove the right to vote, even if that is not what the petitioner wants, and even if it's not what the individual wants. So, in order to be 100% sure that the individual does not lose the right to vote, do not file a guardianship of the person petition. Consider other options. There are other options available that are much less restrictive than guardianship. There are release forms, supported decision-making, a representative payee, and powers of attorney. I have noted that the Wisconsin Board for People with Developmental Disabilities has a toolkit that gives you a lot of information about supported decision-making. And I recommend that you consider supported decision-making as an alternative to guardianship. But sometimes guardianship is the best option to safeguard the health and well-being of an individual. So if it is, do not neglect the right to vote in the initial guardianship proceeding. Be an advocate for the proposed ward's voting rights. Make sure the issue of voting is thoroughly explored. So let's get a little deeper into how to keep the right to vote in an initial guardianship proceeding. The court is going to rely on the opinion of a number of people. The petitioner, that's the person, again, asking to have the guardian appointed. The guardian ad litem, or GAL, we'll talk more about that in a second. The examining doctor or psychologist, and the court's own judgment. All of those people need to be persuaded that the individual should keep the right to vote. And how to do that? Well, to begin with, the petitioner should not check the box in the petition that asks the court to remove the right to vote. The petition to ask for a guardian includes a section on it where you can ask the court to remove the right to vote. And if you are alleging it should be removed, you check a box. If you believe the individual has sufficient cognition to vote, do not check that box. Again, if guardianship is the best option, another tip is to make sure you understand the legal standard. As I mentioned, it's understand the objective of the elective process. And again, I'll go into that more in detail. An advocate should be prepared to explain the legal standard, and the advocate should help prepare the proposed ward to answer questions so that they meet that standard. I mentioned the number of individuals who might have an opinion and the court will rely on them. Well, one of those is the guardian ad litem, and they talk to the proposed ward and then they fill out a form, which is a report. And an advocate should talk to the GIL about the standard and how the proposed ward meets that standard, that they do understand the objective of the elective process. And the goal here with the guardian ad litem is you do not want them to check the box in their report that recommends that the proposed ward lose the right to vote. You want them to agree that the right to vote should be retained, or second best, the GAL should have no opinion on that topic. An advocate should also talk to the examining physician or psychologist about the standard, and particularly these professionals do not seem to understand the standard. So it's important that after we've gone through the section of this presentation on the standard, that you share that information with the physician or psychologist. They also fill out a report, and you want them to check yes when they're asked the question, does the individual have the evaluative capacity to vote? Or ideally, or secondly, not ideally, but secondly, they would not check yes or no. And lastly, and a suggestion is to hire an attorney to represent the individual, to advocate that the right to vote should be retained. The outcome that you want to retain the right to vote is in the final determination order. There will be no check in the box that removes the right to vote. The judge will fill in these check boxes. And one of the options is the individual has the incapacity to exercise the right to, and then one of those options is register to vote or to vote in an election. Ideally, you want a blank box there. You do not want the judge to check that box. But if the right to vote was lost in an election, in a guardianship proceeding, the individual may want at some point to get the right to vote back. So the first thing you need to do is find out if in fact the right to vote was lost. Sometimes people aren't aware that it was lost. So you need to find the right document to look at. It's not in the letters of guardianship. Many people think it should be there, and sometimes that's the only document they have. But the letters list the authority of the guardian. And since the guardian of the person can never vote for the ward, they do not have the authority to vote, it's not going to be in the letters. It's only going to be in the document called determination and order. Now, some orders prior to 2006 are still in existence, and those were granted under an older version of the statute. So it's very possible that those older orders will not include information on voting. And you need to assume that the right to vote was lost and the individual needs to ask to get their right to vote back. So again, if the box in the determination order that talks about removing the right to vote is not checked, the individual can vote. If the box is checked, the individual cannot vote. But again, you can ask to get your right to vote back. Now, you may be wondering why you would want to go back to court to try to essentially reverse the judge's first order. Doesn't that seem impossible? Well, certainly people have done it, as you've seen in Jen's video. So why go back to court? Well, it's very possible that the court made the wrong decision the first time. Many people have guardianship petitions filed for them in an emergency situation. And so voting is the last thing people are thinking about. So the issue gets overlooked. It doesn't get properly reviewed. So in fact, it may have been the wrong decision at the time, but it also might have been the right decision, because particularly with young adults, they may lack maturity or not have had sufficient treatment, but the years pass, they've gained maturity, they've gotten sufficient treatment and community support for their condition, and now they do have the mental capacity to vote, whereas before they didn't. So don't let the fact that someone lost the right to vote in the past deter them or deter you from being their advocate to try to get the right to vote back. So let's talk about some nuts and bolts. How to do this? You have to go back to court. You have to file a form called a petition with the court. The petition has to be filed at the office of the county register in probate. I have the links to all those registers in probate at the end. There's no cost. It's up to the individual who's under guardianship to decide if they want to do this and when they do this. They don't have to get anybody's permission. They don't have to ask the guardian. They don't have to ask their service provider. They don't have to ask the county. It's their decision. There is a time restriction. There has to be at least 180 days since the last guardianship hearing before they can file. Someone can help them. It could be a guardian, a friend. You'll notice Jen had two helpers. She had her guardian and she had her advisor from a service agency. It should be someone who agrees that the individual should get the right to vote back. And either the individual or their supporter can file this petition with the court. An attorney is not needed. The individual can do the whole thing on their own. But of course, since it's a court process, it's going to be easier with an attorney. The individual can find their own attorney and pay for it, or they can start on their own and then get an attorney. If the individual cannot afford to pay for an attorney, they can ask the court to find and pay for an attorney. And I'll show you on the petition how to make that request. So, how you start, as I mentioned, is by filing a form called a petition. And first you have to fill it out. It's easy. And in the guide I mentioned at the beginning of this presentation, we have forms and instructions on how to fill this out. It's very important that you follow the instructions. And the form on the PowerPoint right now is the ward's petition to restore their right to vote. And in addition, there's a sample petition if someone else files it on their behalf. So the first half of the form is quite easy to fill out. There's only a few things one needs to fill out: the county that you're filing in, the case number, which you get from the determination order or from the letters of guardianship, and the date of the determination order. If you don't have that document, you can call the register in probate and get it. And then in number 6, there's a checkbox if you are unable to afford an attorney. And then the bottom half of the form only has a few things to fill out. You can check a box to ask the county to appoint and pay for an attorney. And then there's some signature boxes. I'm not going to explain them now, but it's very important to read the instructions, which will tell you how to fill those out. So you file the petition. What happens next? There's a notice of hearing that's given. The guardian ad litem, also called a GAL, is appointed. The court might or might not appoint a doctor or psychologist. There will be a hearing, and then there will be a decision. So looking now at the appointment of the guardian ad litem, you need to know that even though it says guardian ad litem, it's not, this person is not a guardian, but this person is an attorney. The guardian ad litem is not the individual's attorney. That person, the guardian ad litem, decides what she or he thinks is best, even if that is not what the individual wants. So it's very important that the individual talk to the guardian ad litem and tell the guardian ad litem why they should get their right to vote back. The guardian ad litem will communicate that to court, but will also communicate their opinion on the issue. If the guardian ad litem does not agree that the individual should get the right to vote back, the individual can still go ahead and ask the court to grant their request. Will there be another doctor or psychologist appointed to examine or talk to the individual? It's not required in this kind of petition. The statute, the law, sets out some very specific obligations for the court to do. I've mentioned them, the notice of hearing, etc. This is not one of the things that's in that list, so it's not required. But the court may still want an opinion from a medical professional. So it's very important, again, that the individual talk to this doctor or psychologist about why they should get their right to vote back. And even if the doctor or psychologist believes that the individual should not, the individual can still go ahead and talk to the court. If the individual has a supportive doctor or psychologist of their own, they can ask that person to write a letter of support. Now we get to the next step, which is the hearing. This is a very formal meeting, usually at the courthouse. And this is when the individual gets to explain and must explain to the court why they should get their right to vote back. It's absolutely important, absolutely imperative that the individual attend the hearing. Accommodations can be asked for if needed. Alternative communication devices can be requested. And you can even request that the hearing be held where you live if the individual is not capable, physically capable, or there are transportation issues of getting to the courthouse. And it's at this hearing or meeting that the judge will listen to the individual, any supporters, and the guardian ad litem, and the doctor or psychologist if one was appointed. And then the court makes a decision. They will put their decision in a written document called an order. We have a sample in that guide that I mentioned to you earlier. And if you win your case, you can use that sample. It's important to get a copy of the court's order. The court's also going to fill out another form and give that to the elections clerk so that you are put on a list of eligible voters. If you are successful, you need to register to vote and bring a copy of that judge's order with you when you register and when you vote, in case there's been some mix-up and it hasn't been communicated that you now have the right to vote. Now let's turn to how to prove the capacity to vote. Again, the phrase is incapable of understanding the objective of the elective process. This is a different standard that is used when appointing a guardian of the person. That standard focuses on the inability to meet the essential requirements for his or her physical health and safety. And as you know, voting has nothing to do with physical health or safety. So because the legislature chose incapable of understanding the objective of the elective process, sometimes that's a mouthful, even though I've said it so many times. They chose that phrase and did not choose anything to do with physical health or safety. So it must mean something different. What does it mean? There's no definition in the statute, and there are no court cases interpreting it. It's a different and lower standard than the standard for appointing a guardian of the person because, as I noted, health and physical safety are not involved. It is not a civics or citizenship test. You don't have to know what the Bill of Rights are. You don't have to know balance of power. You don't have to know the Constitutional Convention. You don't have to know anything like that. Consider what the standard is for testing the capacity of other voters. There is none. None of the rest of us are asked to explain our vote or explain the process for voting or explain why we're voting for who we're voting for. There is no standard for anybody else. And so the standard for people alleged to be incompetent should be as minimal as it is for the rest of us. It's important when proving capacity to vote to understand that it's possible for an individual to have the capacity to vote, but lack the capacity to exercise other rights. And it needs to be proven by clear and convincing evidence that the right to vote should be taken away. Now let's turn specifically to what those words mean. We have to look in the dictionary because there's no definition in the law. I looked up objective, elective, and process. And when you put the meaning of those words together, the phrase means to understand the purpose of an election. And the purpose of an election is to vote for the candidate that the voter wants to win. So it's a very simple standard. And the most important question for the individual to be able to answer is, why do you want to vote? And you heard Jen's explanation. She wanted a choice of who to vote for. She understood the purpose of voting, which was to make a choice of someone to make decisions for her. There are other questions that you might want to discuss with the individual, and the court might be asking in addition to why do you want to vote? These are, why do we have elections? What is the purpose of voting? How do you decide who to vote for? How do people vote? What offices are on the ballot? What experience have you had with voting, such as in school clubs? Do you have a photo ID and proof of residence? One question that you should not be asked, and you do not have to answer, is who you want to vote for. You can volunteer that information, but that is really a confidential piece of information that you do not have to offer if you don't want to. So it's important for advocates to prepare the individual for the discussion with the guardian ad litem and to explain to them the court experience. At the hearing, if possible, have witnesses who can attest to the individual's understanding of the elective process. It could be teachers, caregivers, etc. And this support can be provided in person in the hearing or through letters of support. And as I mentioned, accommodations can be requested as needed. Now, almost getting to the end, some important resources. Again, the DRW Voter Hotline, a very useful resource for anything having to do with voting. Again, the number is 844-347-8683. Email is info@disabilityvote.org. Another useful hotline is the Wisconsin Guardianship Support Center. They provide a wealth of information and assistance related to adult guardianship, protective placement, and advanced directives. Their number is 855-409-9410. Their email is guardian@guar, which is spelled GWAAR.org. GWAR is their umbrella organization. So remember the voter hotline run by DRW and the Wisconsin Guardianship Support Center. There are a number of other resources. DRW's Guardianship and Voting Resources page is very useful. Just Google, I've got the URL there, but just Google disability, or just put in your URL, disabilityrightswisconsin.org, go to the resource page and look for guardianship and voting. Wisconsin Disability Vote Coalition, disabilityvote.org, has a lot of useful information. So does the Guardianship Support Center. And they're also the directory of Wisconsin probate offices. So in conclusion, some takeaway points. The only way to lose the right to vote is through a court process that follows the procedures in the guardianship statute. In order to lose the right to vote, there must be clear and convincing evidence that the individual is incapable of understanding the objective of the elective process. If the right to vote was lost in a court proceeding, the individual can later petition the court to have their right to vote restored. But the individual must establish that they now understand the purpose of voting. So thank you very much for watching, and we appreciate your time and attention and hope that you feel motivated to help individuals retain or restore the right to vote. Thank you.